evidence presented during the trial. A fair, impartial, and just verdict depends upon the combined efforts of the jury as fact-finders, the judge as the presiding officer and authority on the law, and the lawyers as examiners and advocates. A trial by jury begins with the jury selection process called voir dire, an Anglo-Norman term meaning to speak the truth. During voir dire, prospective jurors are questioned concerning any possible relationships they may have with the parties involved, or if they have any prior knowledge about the facts of the case. The candidness of the juror's response is of the utmost importance because the jury trial system is dependent upon it. The judge and the attorneys will ask the juror specific questions to determine if the juror can be impartial. Each party in a case is given a number of peremptory challenges. A peremptory challenge to a potential juror is one of which no reason need be given to the judge. Each attorney is granted a specific number of peremptory challenges depending on the type of case and an unlimited number of challenges for cause. And should any attorney wish to excuse a potential juror for cause, he or she must state such cause to the judge, who will then rule whether the attorney's challenge is proper. There's no reason for anyone to be ashamed or embarrassed should he or she be excused. When a juror is excused, it is in no way a reflection upon the juror, nor does it question at all the juror's competence. The questioning and challenging continues until the number of jurors needed for the trial has been reached. Before the trial itself begins, the jury will be sworn to well and truly try the issues between the parties and to render a verdict according to the law and the evidence. When the members of the jury are sworn, they virtually become judges on every question of fact presented in the case. A juror is bound to act fairly and impartially. Jurors are not free to act upon their own feelings and emotions, but must use sound judgment and reason and must follow the instructions of the judge. Now let's discuss the trial procedure and your involvement with it. Once the trial begins, the attorneys usually make an opening statement detailing the evidence that will be represented in the case. An important thing to remember, opening statements are not to be considered evidence. Rather, they are each attorney's belief as to what evidence and facts in the case will be presented during the trial. The opening statements are not to be considered in arriving at your verdict. Let's talk about evidence. Evidence involves witness testimony, exhibits, and objects used to establish facts of the case. It might be a document, a gun, a tool, a photograph, or some other tangible thing. Oral testimony of witnesses is also evidence. In fact, most of the evidence in the majority of both criminal and civil trials is witness testimony. You must pay close attention to each witness when they testify. Since you are the judge of their credibility and believability, it's your sole responsibility to sort out the facts from all the testimony and evidence presented in the case. There is another serious responsibility of the juror: confidentiality. During the course of the trial, the judge will advise you that you must not speak to anyone about anything that has occurred in the courtroom. Even talking with your spouse about the case can be an act of contempt, punishable by fine or imprisonment. A prudent policy for you to follow is to avoid even the slightest appearance of an improper discussion. As a matter of fact, should you believe someone has purposely tried to talk to you or talk in your presence about the case, you should tell the judge immediately. While you are in the courtroom, elevators, corridors, lunchroom, anywhere, please make sure you do not talk with the lawyers, their clients, the media, or anyone else who may have an interest in the case. Also, you should be aware it would be in violation of your jury duty to conduct your own investigation of the case. You must not visit the scene of any accident or alleged crime, and you must not make any attempt to question witnesses other than what the judge might permit in the courtroom during the trial when everyone involved in the case is present. Sometimes during the course of the trial, the lawyers will approach the judge to hold private conversations. These conversations are not intended for you to hear because they concern technical points of the law and courtroom procedure on which the judge alone must decide. Sometimes the judge might excuse the jury or recess the court to resolve the matter, either in the courtroom or in the judge's chambers.